welcome to each and every one of you. I'm David Girard-diCarlo, and with my wife, the program that's being put on today is sponsored by our Center for Ethics, Integrity, and Compliance. Some of our board members are here. We had our board meeting just recently. Unfortunately, several of our board members had to leave for their own activities. I'm not going to introduce the panel members. I am going to introduce one of our board members, the Honorable Marjorie Rendell. She is a member, as I said, of our board, but she's a graduate of the law school in 1973. She was a distinguished partner at the Duane Morris Law Firm before joining the federal bench, and currently sits on the Third Circuit bench. And it is our great pleasure that she will step in for Professor Chananson, who is our center director, but unfortunately he is in the hospital. He has a medical challenge, and we hope everything is going well for him. With no further ado, I will introduce Judge Marjorie Rendell. Judge.
Thank you, David. And good afternoon. Yes, our topic today is the limits of advocacy, and we're going to explore this topic in different contexts. Are there limits in the courtroom, in simply advising clients? What are the limits? Who is supposed to impose them? And what happens when they are threatening our institutions? Also, are ethics and compliance and integrity the same thing? And we're so fortunate to have an illustrious panel who've graciously taken time from their busy schedules, and many of them traveled, to help us answer these questions. And I'll introduce them going from my left over to the right. Judge Mark Kearney, colleague on the District Court of the Eastern District of Pennsylvania, nominated by President Obama in 2014, a well-respected commercial litigator in the Montgomery County Bar, president of that bar association, president of the Pennsylvania Bar Institute, and now a member of the Villanova Law School Board of Consultors. So, Mark, happy to have you here. And I'm probably going to call on my colleagues here by their first names, meaning no disrespect. Second, we have Maryann Clifford. Maryann is a respected lawyer and business leader with senior executive experience working for 3 multinational Fortune 500 companies. She also has extensive litigation experience for the U.S. Department of Justice and in private practice. Her last corporate role, she assumed the responsibilities as the Global Chief Ethics and Compliance Officer at BP in the aftermath of the 2010 Gulf of Mexico oil spill. So she has a lot of wisdom that she will bring to bear. To my immediate right, Ben Ginsberg, nationally known political advocate and compliance expert. He's represented 4 of the last 6 Republican presidential nominees. He co-chaired the Bipartisan Presidential Commission on the Election Administration, which produced a much-lauded report of best practices and recommendations for state and local officials to make U.S. elections run better. And I must say, in his previous life, he was a newspaper reporter for the Boston Globe and the Philadelphia Evening Bulletin, which is no longer. Welcome, Ben. Last but not least, Professor Abby Smith, who is a professor of law at the Georgetown Law Center. She's the director of the Criminal Defense and Prisoner Advocacy Clinic. She was the deputy director of the Criminal Justice Institute at Harvard Law School. She has taught at the University of New York School of Law, Temple, and American University. And her forthcoming article is entitled, "Can You Be a Legal Ethics Scholar and Have Guts?" We may get into that a little bit later. All right, so let's start off where probably a lot of you are thinking we might start off. And that would be the election fraud cases, the outcome of the 2020 election. And Ben has a lot to say on this topic, and let's start with you. How were the limits crossed in connection with some of these cases that were brought across the country? And what could cause a lawyer to go to those extents and to that extent in pursuing these causes?
Well, thank you for the question, Judge. Judges, by the way, when you get into court, always sit higher than anybody else. So this is good training. Thank thank you for having us here, David and Connie. It's terrific that you fund this center and do this program. The question you asked really goes to the heart of so much of what we're dealing with in the aftermath. I have to confess that I come from the political battlegrounds, but in dealing with the questions you raised about ethics, I am a little bit chastened by an experience I had as a first-year law student at Georgetown University, where a legendary professor named Sam Dash, who was the Watergate prosecutor, taught professional responsibility. And most of you probably know who John Dean was, a White House counsel who got a little bit messed up in the Watergate scandal. And Sam Dash said on the first day of class, I'm going to teach you all the rules of professional responsibility. But I want you to know that in the 30 years I've been teaching at Georgetown, the student who got the highest grade in my class ever was John Dean. So in asking your question, you can teach the rules of professional responsibility. Following them ethically is much more of an internal exercise for an individual. And so I think a lawyer has to sort of constantly recalibrate his or her internal gyroscope on ethics questions, which is why, to bring it to the 2020 election cases, I think some people got mixed up a little bit. Pursuing post-election cases is something that's built into every state statute and law. So the fact of zealously representing a client in a post-election case is what lawyers should do. And, there were 64 cases brought by President Trump or former President Trump and his supporters in there. And many of them actually were cases that should be litigated. If you are a lawyer, you will find, especially in the post-election litigation, that there's a huge volume of material that you have to sort through. And because our political cases are so much in the public eye and involve so many quick decision-making, there are going to be cases that have been brought by Republicans and Democrats alike that fall by the wayside. But there was a point where a number of the cases went off the rails, where lawyers were filing cases that had no legal background, no evidence to bring them back. And that's the sort of interesting position a number of lawyers found themselves in having to deal with that. And I think the real kernel to be gotten from those cases is the ability of lawyers to sort of recalibrate their internal gyroscopes if you're in a position like that where the stakes are so high. The clients that you have, whether they're political or anything else, are really demanding of an outcome. And the tension between your desire to represent your client well and doing things that are perhaps beyond the pale. And so how lawyers get themselves into this situation is, I think, really comes down to the age-old question of, does the end justify the means? Do the means justify the ends? And I think the lawyers who went off the rails in the post-election period sort of thought that the end was so morally cataclysmic and imperative that their candidate won, that they ended up doing things that in a calmer moment with a better adjusted internal gyroscope, they wouldn't have done. And so it's a tension that all of you will face in your professional careers in one way or another, whether you're acting as a lawyer or a lawyer acting in another capacity.
But two things occur to me, though. If these cases are election fraud cases, any lawyer, and I'm sure law students, you learn you have to plead fraud with particularity and prove it. So a lot of these cases were brought and hoping for there to be an inference, but the lawyers certainly had to know better, that they needed actual evidence and particular evidence. The other thing that occurs to me is these are such high-profile cases. Wouldn't it be even more reason for a lawyer to hesitate before bringing them and losing credibility and respect? Yes, Abby?
Hi, thank you so much for having me. Is my microphone on? Okay.
Turn it up.
Like that?
Eat the mic.
Okay. I believe in lawyers. And it was interesting to me that Trump had the fewest lawyers in his administration of any president in the last 50 years. Why do I believe in lawyers? Because we operate under a code of conduct. We are the embodiment, or we're supposed to be, of the rule of law. That's what it says in the ABA's Rules of Professional Conduct, which control in every jurisdiction in this country now, with some variations state by state. We're supposed to demonstrate respect for the legal system. We're supposed to both challenge the rectitude of official action, but also uphold legal process. I appreciate Ben Ginsberg's comments about lawyers getting too close sometimes to clients and acting overly zealously. I am a career criminal defense lawyer. I understand what it means to zealously represent individual clients, and I think probably every lawyer practicing in every field at some point in our career have a case that really tests us, where we get too close. I don't think, and I think it's way too compassionate, to explain the conduct of Trump's lawyers from that vantage point. I believe they knew exactly what they were doing, and I'm afraid my colleague and old friend Sam Dash would be rolling over in his grave to hear it was very kind of you to say they got a little mixed up. I think that's an understatement. They went off the rails. I even think that's an understatement. I think they engaged in ethical misconduct. They embarrassed the legal profession. You know, I believe in lawyers. I'm a really happy lawyer. I felt ashamed to be a lawyer because of the conduct of people like Rudy Giuliani, Sidney Powell, Jeffrey Clark et al. And Jeffrey Clark was operating in the Justice Department of the United States. That's where there were supposed to be some breaks. Lawyers are supposed to, among other things, when they have a client, and I don't envy any lawyer who was Trump's lawyer. He must have been an impossible client to counsel. Nonetheless, we have an obligation to candidly counsel our clients and say no when the client wants to engage in fraud. And this wasn't just fraud. That makes it sound kind of ordinary. He wanted to dismantle the democracy that we all live in. He wanted to undo the rule of law. He wanted to assert executive privilege at every moment. It's really dangerous. It was dangerous then. It remains dangerous now. And just so that you know, I think lawyers have a responsibility. One of the things lawyers are supposed to do is call out other lawyers for misconduct. Why? Because we are a self-governing profession. We're independent on account of that self-governing nature of the profession. But it means we're supposed to call out other lawyers. I'm really proud to say, look, in my career as criminal defense lawyer, I've always said my two favorite words are the words not guilty. But in the aftermath of the Trump administration, my two favorite words, and I was a participant in this effort, are the words Giuliani disbarred. I've been part of an effort to file disciplinary complaints against Giuliani, Sidney Powell, Jeffrey Clark, Kellyanne Conway, anybody and everybody who I think has done real damage, not just to the bar, but to the country.
Let me
But
jump in here.
there's a problem that needs to be talked about. Abby is made the statement about all lawyers. So she named 5 Trump lawyers who indeed deserve disciplinary action. But we are in such a tenuous position that political passions end up talking about all Trump lawyers, which I think was not true because there were 64 cases filed, and a number of them were perfectly legitimate post-election cases to bring that I brought before, that my Democratic colleagues had brought before in similar circumstances. So, if we're talking about the profession and how to discipline the profession, Abby is absolutely right about the 5 that she named, but we have to be really, really careful in the way we use the language to talk about the vast universe.
And I think that's correct. And let me make a little bit of a disclaimer. I am a federal judge. I do not do politics. We are trying to be very factual here, and I think Ben's point is well taken that as a factual matter, and one of my colleagues, Judge Bibas, who was a Trump appointee, was one of the judges who wrote an opinion saying the district court is affirmed because there was no there was no evidence. So we're talking facts here. I want to point out.
And Judge, just briefly, Judge Bibas affirmed a district court judge who was appointed in the same way. He was national president of the Federalist Society. They filed the case in Williamsport, Pennsylvania. There's a single judge in Williamsport, Pennsylvania. They found a voter in Williamsport, Pennsylvania because they could go to that judge. I'll talk a lot about this later on, about outside the political realm, but just understand, Judge Bibas and Judge Matt Brand, both of whom, they did Judge Bibas, they went to Judge Brand. They searched him out.
Yeah. And, you know, we have rules. The rules of civil procedure, Rule 11b3 says lawyers are not to make factual allegations that lack evidentiary support. I mean, this is a rule that we live by. And Rule 11b1, lawyers are not to use filings for improper purposes, such as to harass or delay. Now, Mark, you have had a couple recent experiences, and your colleague, Judge Goldberg, has had recent experiences involving bringing of case without evidence in the criminal realm, I guess in a habeas case. And you had one where you wrote a 18, 20-page opinion about the harassment and delay in a civil case before you. You want to comment on that?
I think it's important, what Ben and Abby are saying is important, but let's be candid with each other. There's very few of us who get called upon by the President of the United States to represent them. Ben may be one, but most of us do not. But what happens every day is we get called upon by clients, and what's happened in this culture is people will do anything in chase of the almighty buck. And in two recent cases, my colleague and dear friend, Judge Mitchell Goldberg, and I, he in a case involving a habeas petition involving a district attorney, where a district attorney misstated, omitted, judge was rougher in language, and actually kind of nice in what the sanction was. But in that case, they told the judge something that simply was not true about a victim of a crime to allow a man to go free. Now that sounds great. That's laudatory. Abby's clapping over there, right? The man, in a criminal offense sense, right? But the problem was there was a misrepresentation made of all the way to the very top law enforcement official in the fifth largest city in the United States. The very top guy directly did not disclose this information to a federal judge. The federal judge found out. Judge Rendell and I really talented people that work in our chambers, and we kind of find these things out, right? We kind of read things. And we found out, and Judge Goldberg called him out on it, and wrote a very lengthy opinion I commend it to you, to talk a lot about the idea of candor in the criminal context. What's interesting about that case, very briefly, is that it's weird because he doesn't have a paid like a Trump, in my case, a massive corporation where you kind of see, in this case it was a DA. What was he thinking? Why did he think he'd get away with it? Why did he think the judge was going to catch it? What scares me, Mitch, is that I think there's no way you and I can catch all of it.
No, for sure.
Right?
No,
On the civil side, just very briefly, these lawyers went to battle in a case simply to put leverage on the other, and they just fought and fought and fought and fought and fought, and at the end of the day, they had nothing. They literally had nothing. And I called them out on it and bounced their trial, and I said, all you're doing is harassing. I use a quote that I share with you. I said, you've hijacked the public square. You're sending me 22 motions a day. Believe me, I have Abby's clients who need real care. I have Maryann people. I have corporations that need relief. And you're coming here every half an hour, so I won't use a colloquial, but with something you wouldn't talk about nicely, and laying it on my desk. And it's complete lies. I'm telling you, lies by major law firms that recruit you and pay you $145,000 and then ask you to lie. Let me tell you what we did. Both Judge Goldberg and I went after the associates. I want to tell you that. We condemned the partners, but we went after the associates because they have an obligation to stop it. Remember, you're a paid employee as an associate. You don't know that yet. You'll learn that soon. And the partners are tending the funds, in some sense. And so the associates are just do what they're told to do in many cases. Except not as a lawyer. As a lawyer, you have to say, I'm not filing that. Kearney's going to figure it out in half a second that we're lying, because last week we said the exact opposite. I kind of remember that. I'm urging you to think about this in this context. I did not sanction, Judge Rendell. I did not sanction. But I sanctioned by an opinion. It's over many law schools now. It teaches a lesson about how far you can go. I said you didn't cross an ethical line. They didn't cross an ethical line. They fibbed around with you. We didn't cross an ethical line. Boy, they violated every common sense rule that you can apply. The kind of things that Villanova lawyers do not do. They did regularly.
You know, in our meeting earlier today, David Girard-diCarlo made a point, and it has to do a lot with the culture of the place where you work. And, you know, you can say, I'm not going to do this because Judge Kearney's going to find out. But shouldn't you say, I'm not going to do this because that's not who I am, and that's not what's valued in my realm, in the climate of my firm. And if you're in a place where the climate is, well, get away with it if you can. Get out. Maryann, you've had a lot of experience representing corporations and within corporations, when lawyers are maybe not acting to represent clients as such, but are as part of the company. What disciplinary rules apply in that situation, or should apply in that context? You're not necessarily in litigation. You've got ethical and compliance considerations. Are there tensions there?
Yes, thank you. Again, I'll echo my colleagues. Thank you for having me. David, you said the magic word this morning, culture. And I think what I see is a culture now in this country where we're much more tolerant of lying, and just flat out lying. And people, if you read the paper any day, including yesterday, 71% of the people polled in a recent poll said they believe our democracy is at risk. And they're willing to vote for people that they know are election deniers. To me, and I'm not speaking as a lawyer, I spent my last 20 years as an ethics officer, and there is, sorry to say, there is a difference. And in fact, we are often in an ethics officer role at odds with someone in legal who might be saying to you, some examples, and I don't attribute anything to the three companies I'm working for, but handling an investigation where the outside lawyer would say to you, well, this is like litigation. You know where you need to be at the end of the day, and you investigate and work to that end. Not true. It's not true when you're conducting an investigation. And so, yeah, there are odds. And to your question, Judge, and I can't get used to calling you Midge, but to your question, I think we're way too lenient. I'm leaning a little bit over here to my colleague Abby on this one. Lawyers are self-policing. And in a corporation, you don't have the same First Amendment rights. The company tells you what the rules are, and you abide by the rules or you're out of there. Lawyers, of all people that are held to a high standard to protect our democracy and the rule of law, the fact that they're not disciplined, I would have disciplined and sanctioned those lawyers. I read your opinion. I think that the Philadelphia District Attorney got off way too light with the slap of the wrist. And I think not only do we need to discipline as a group, all of you, as you become members of bar associations, need to take an active role in not only promulgating tougher rules, but taking action and being heard. Because if you don't talk about it, it doesn't exist. And I'll stop there except to say, as you look at the evolution of ethics, I think that where we are with the issues right now that we're facing around elections and election deniers is that we need to move past rules and we need to move into a forum where people are willing to speak up and talk about it, get involved in the elections, and demand, as Abby's trying to do, that people are held accountable. I'll stop there.
Then why would Rudy Giuliani pursue a claim without evidence? And wouldn't it be up to the lawyers when these 60 cases had gone awry? Shouldn't they have an ethical duty to call them out and say this is wrong? I don't understand the motivation. And maybe it's because it is high stakes politics, but I can't fathom it.
Well, I think you need to separate a few things out. If you're a lawyer whose candidate has lost a race narrowly, it's not like a normal fraud case where you have some time for discovery and to deal with the whole process. You have to be in court generally within 3 weeks, depends on the state, presenting your case. And often the discovery process itself is the way you end up proving those cases. It was certainly true for us in Florida in 2000, which was a legitimate recounted ring on both sides. And with Rudy, I'm not going to defend Rudy Giuliani. I think to use, I don't know what happened to him. There's really no excuse for that. But in the general course of things, numerous lawyers in that case did have affidavits that were presented to them that they used in court. They claimed they didn't have time in the 3-day period that they had to actually sort through the affidavits and see if they were reliable. That's a fault of the lawyers for not being sure that the affidavits were right, but they weren't, they thought, making it up out of whole cloth. So the recount cases are, in many ways, not a perfect example of the ethical things you're asking about because the timetables are so conflicted. But I think Rudy Giuliani and John Eastman and Sidney Powell are examples of people who were trying to please a client and thought that the end justifies the means. And that's always wrong, and it's why you have ethics rules to prohibit that, punish that.
Let's talk a little bit about how this all fits within the lawyer's duty to safeguard the rule of law. We had an essay contest at our court last year, and it was amazing. 5th graders researched the rule of law and wrote wonderful essays, and they admitted, and the teachers admitted, they had no idea what the rule of law was before they did this, but it was wonderful. It seems to me that the lawyers who are willing to do the client's bidding without question are doing a tremendous disservice to the notion of our profession as guarding the rule of law. So Abby, how can you look beyond or be an advocate while adhering to the rule of law? It's a challenge, is it not?
It is a challenge. You know, there are so many lawyer jokes out there, most of which have to do with lawyers' inability to recognize the truth, frankly. And, you know, not to mention lawyerly greed. I actually tell my students that, you know, I think lawyers are compulsive truth tellers, frankly, that the opposite is true when it comes to our relationship with our clients. You have to tell some unpleasant truths sometimes to the people you represent, whether it's in a criminal context or a corporate context. That's what it means to candidly counsel.
At the risk of losing the client.
At the risk of losing, hopefully you've built enough trust so that you have some credibility, and that's on you as a lawyer as well. But I believe in advocacy. I don't have any problem with political candidates having lawyers. I don't have any problem with a relatively, in the past 3 decades, new occurrence of alleged victims having lawyers. I don't think more lawyers is necessarily a bad thing, so long as the lawyers comply with the rules of professional conduct. There's an old adage, and I forget who it's attributed to, but lawyers must be honest. We don't have to be truthful, but we must be honest. What do I mean by that? I mean, every time on behalf of a client I enter a plea of not guilty for somebody who might be factually guilty, that's not exactly truthful. But I have to be honest in all of my dealings, especially with the courts. And I just want to say, I don't mean to, sound like a hysteric, but the risks here are enormous. Lawyers play a critical role in supporting and lending legitimacy to every bedrock institution that we have, whether it's elections or courts or the idea of the rule of law as something concrete that we can rely upon. And when lawyers lie or intentionally offer misleading information, I think it creates an existential threat to democracy itself. You know, it's why I think what's going on right now between now and November 8th, efforts to fight the suppression of the vote, efforts to get out the vote is essential. And that's why I'm heartened when there are lawyers who are legal observers at polling places. It kind of makes a difference just to have us there.
What about the Republican efforts to recruit more poll watchers?
It's been so written about. Is that?
I'm fine with poll watchers. I'm not fine with voter suppression. And I'll tell you, I have a little example of what happened in Savannah. So I did election protection for the Democratic Party in Savannah, Georgia, January 5th, 2020, the day before January 6th. I actually was driving back to my home in Washington, D.C. when suddenly there was a curfew because all hell had broken loose. I spent a couple of days in a warehouse in Savannah. I wish C-SPAN had been there because the allegations of voter fraud are so bizarre. People are randomly seated at tables. There's older African-American women seated with younger white men from all parties, sorting out absentee ballots or the kind of ballots in those jurisdictions that still have you fill out the circle to figure out whether it's filled out completely. Sometimes there are people for some reason they're shaky when they're filling out the circles, or they're, random pen marks. That's where lawyers come in. And so I was involved in both incredible tedium, waiting for there to be moments to take a look at the ballots, and then suddenly it was really interesting. There were 2 lawyers for the Democrats, 2 lawyers for the Republicans. Then I have to say, it's why you can't generalize from one anecdote, but I found it really depressing. I was willing to say as a lawyer, and maybe it's partly because, the civil servant who was deciding these ballot questions, I felt like part of advocacy is you need to be a little credible. When there was somebody who had filled out a ballot, clearly meant to vote for the Republicans, and there was just some stray marks or it wasn't totally filled in, I was prepared to say, consistent with the statute in Georgia, that you're supposed to err on the side of the franchise on allowing people to vote. I was willing to say, sure, that looks like that's who they intended to vote for. Every single time there was a ballot by somebody who clearly intended to vote for Warnock and Ossoff, there was like a big to-do about how the ballot shouldn't count. I don't think that's what lawyers should do. I think lawyers should act consistent with the statute and, frankly, consistent with people's right to vote, which is the essential part of a democracy.
Well, politics is so high stakes now. It is the be-all, the end-all. I mean, we see that with the impact of elections on the Supreme Court, the impact of elections on so many things, and yet, you're right, our institutions are being threatened. Our profession, the courts, our democracy, the rule of law, these are all being threatened. Maryann, you've had experience in the global arena. What do you see in terms of the rule of law and the way it's being threatened here, and what impact there might be from a global standpoint?
And yes, thank you for that question. I think we don't always think about that side of it. We're so wrapped up in what's happening in our own political environment, and I serve as a co-chair on a board of an organization that was initially set up by the American Bar Association called the Sealy Institute, and our mission is to promote the rule of law. And I think when you said what is the rule of law, a lot of people don't really understand, but it is about an independent judiciary. It is about making sure that we're fair and open. And what has happened that I've seen, and it's not just been since the 2020 elections, but even before that, our standing in the U.S., outside of the U.S., has eroded dramatically. We went into many countries after the Soviet Union broke up in the 90s. Lawyers just put down their books here and went out to all these countries to help them set up political processes and courts and judges have been involved in it. Today, not so much. They don't really want to listen to us. We're a bit of a sideshow, to be honest. And it's kind of a sad commentary, but I think when we talk about, in corporate world, we talk about tone at the top and leadership. And the tone at the top over a period of years here in the U.S. was not so great. And that is heard loud and clear outside of the U.S. We've dropped, there's a civil society group called the World Justice Project. Some of you may be involved in some of these groups doing volunteer work. The U.S. has dropped in its ranking over the last few years. Some of the countries where we've been working with judges and lawyers, like Ukraine, like the Czech Republic, they're getting higher ratings than we are now. So we should really be cognizant of what's happening and how our behaviors are being seen outside of the U.S. and taking steps. Each of us can do that. I mean, you can go work at the polls. I had a couple of Villanova law students a number of years ago working with me in Ohio, doing exactly what Abby was doing. Voter protection work, just answering questions, being there to see what's happening, so that you can do more by being able to react from what you see. And I think it's important, particularly if you're going to be working outside of the U.S., to be able to address those kinds of questions that you'll get. I get them all the time from people like, how can you preach to us?
We're viewed as hypocritical.
Yeah, they view it very much as hypocritical, that you're trying to tell us what is the right way to do things. You know, sorry, we're not buying that now. And so we've migrated over, as we have anyway, to talking more about the international laws, the EU human rights laws, the UN conventions, things that apply more broadly than U.S. law, which is frankly where we should be anyway.
And do you think that the general public in the U.S. is getting either dumbed down or jaded by the thought that, you know, lawyers are protecting the rule of law, that we're just becoming hired guns to so many people, so that, you know, the ability to kind of get our profession back on track, you know, is a real one. Mark, what do you do when a lawyer comes into court and you can tell the client is running the show and the lawyer is just at the client's mercy?
Yeah, there's a great old line, I'll teach you a little secret. When a lawyer says to a trial judge, my client's position is, that's a tell, you know, that's a tell to the judge. I don't believe a single thing here. But my client's paying me to say this, and I hear that a lot. I want to, so what the judge has to do is realize that we're dealing in facts, and you're dealing in facts. I want to follow some areas. 10 days ago, I was teaching, I had the opportunity to teach in Galway, Ireland, and a student came up to me at the university afterwards and said, you were appointed by President Obama. Does he call you about your decisions? Now, he's not kidding, guys. This is an educated man in a law school who had, before he did that, was an accountant for many years. I talked to someone, I'm inviting him over to be an intern in my chambers. And he said, this president, they literally think, this is an educated person. They think, oh, well, yes, I write it out and send a draft out to Chicago to the first lady and the president. And you know, but I want to say something else about the jury. As you made a very good point. I tried a case about 3 weeks ago. I said to the jury after, which was the thing? The jury said, well, we know the lawyers are just lying. We know the lawyers are just lying. My law clerks had just begun, right, term, looked at me with this great sadness. And they said, I said, what do you mean the lawyers are lying? Well, Judge, they're just telling us things that they know, and you're essentially just telling us what things we think we need to know. I'd like to know the whole thing. The adversary system problem is that the rules of evidence are only about things that are actually verifiable, that can justify going to court. But the jury wonders why they don't hear the whole story, and then they wonder why, then they think the lawyers are lying. I explained it about lying, but what's interesting, one woman said, then they all came around and said, well, you know, there was a young woman, there were several lawyers, big client case, and there was a younger lawyer that presented some testimony, asked questions, and we really liked her. Because remember, Judge, she said, Your Honor, I don't want to go there. That really is not very helpful to my case. She said it to the jury. I don't want to go there, Judge. That's not very helpful in my case. Ain't that the Jim Carrey movie, Liar, Liar? This will kill my case. She actually did that. And she got instant credibility. Judge Mandel knows on the Court of Appeals, the best thing you can do is tell an appellate judge is, hey, by the way, that's not my best argument. I know I made it. But your clients don't know that. Your clients think, go, go, go. And I'm just telling you, you only have one reputation. And when you come back to that next client, if I think you're Fibber McGee from last time, I'm going to remember that. So your new client is getting a little bit discounted. I'm still calling on the facts. On the tip ball, you get a little discount. They say, last time Joe was in front of me, I don't know if Joe told me the full truth. And I wonder if he tells his client the full truth. So here's what we do, Mitch. We bring in the clients a lot more.
That's right, yeah.
We bring in the clients a lot more. I say, right, every continuance now, I have the clients come in. Because the lawyers say, oh, I'm too busy, I got to make this. I find out, my intern would say, they're on Instagram, they're floating around Boca. I thought they were too busy. Everybody goes to go to Boca, I get it, but I thought we had a trial. So now I make the clients come in. They're a little bit different.
Yeah.
That higher seat we had then kind of helps in those things. When you're sitting there saying, Mr. General Counsel, you really on vacation next week?
Well, that brings up the question, what's the difference between personal ethics and professional ethics? Is there any difference? Should there be a difference?
I might jump in.
Yeah.
I don't think there should be a difference. I think that if you carry with you certain values and you believe in treating people with respect and being fair, that's what you carry over in your work. And so many of us, they get excited about representation, or they feel that they can exaggerate things. But I think what you're seeing now in corporations, and the last survey that I saw, more CEOs have been terminated for bad behavior, especially after the Me Too movement, than for poor financial performance.
And dishonesty as well.
And dishonesty, fraud, the whole gambit. Does that mean the CEOs that we have out there, are less honest than others? No, but it does mean that people are speaking up. And it means that when somebody talked in the Me Too movement, others were empowered. When people talked about how the CEO at Uber was a bully, he's gone. And so I think that's all personal ethics. I mean, it's what are you willing to tolerate, and what are you willing to tolerate as a lawyer when you're working with clients or working in a corporation where you hear things that just don't sound right. So I think they're absolutely the same.
And the climate that won't put up with the CEO, whereas maybe 10 years ago, they go, oh, Joe, we're doing fine. We've had, profits and, put it under the rug, basically. But now people are paying attention. I had a situation, a case before me where a woman didn't report the boss for the sexual advances. And under our standard, whatever she did had to have been reasonable. Well, it used to be that we would look at it and say, well, it's unreasonable not to report your boss. But in light of the Me Too movement, and you saw 50 women on the front of Time magazine who had been abused and had never reported it because they lose their job, what would be reasonable in that situation, and it changed. So, our perceptions of things, and again, the perception of lawyers as being just the hired hands. We don't realize it, but as we live and breathe, we get these perceptions that can be good in that one instance, or can be bad with respect to lawyers.
I just wanted to add one point on that. You talked about it, that when I first started working as an ethics officer at one of the companies and published a little article that put out in kind of like your newspaper here about bullying and the fact that we not only didn't we tolerate it, but we had terminated some people for bullying, which of course a lot of employees wouldn't believe. I can't tell you how many emails, personal visits, and calls into our hotline we got as a result, because they're like, exactly what you said. I left this company 15 years ago because nobody would do anything about the bully. Now you're talking about it, now you're telling me that you're willing to take action. And I think it's the same, we've been dealing with the bully on the political side, and we're dealing with a lot of people now that are running for office that are trying to bully other opponents. And again, unless we speak out and do something about it, it's not going to change as quickly as we hope.
Yes,
Can I say something? I sort of feel like there should be a moment of silence about what Maryann was talking about the perception of Americans and American lawyers and American courts these days in the world. That's really depressing. I wanted to comment about the personal and professional ethics question. I think you'd like it to be so. You'd like to have your personal ethics and professional ethics be harmonious. That's not always so in the practice of law. And in fact, there's a rule that specifically relates to that. It's Rule 1.2 of the Rules of Professional Conduct that say that a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. There's an out. We represent clients who sometimes you might feel a little queasy about. And that's the constant question that's asked of criminal defense lawyers in the clients that we represent. And it calls to mind one thing I just feel compelled to share with this audience, and it's what Professor Monroe Friedman used to say to law students over the years. He died a couple of years ago. He used to say, especially to first-year law students, as you contemplate the practice of law, you should understand that you may be called upon to represent people who, out of sheer greed, will hurt and even kill other innocent people. And if you can't handle it, you should not go into the practice of corporate law.
Well said. You know, there's been a debate recently about the concept of zealous advocacy. In fact, the Pennsylvania rules, the rules of professional conduct doesn't talk about zealous advocacy, but the commentary does. And, you know, a lot of judges will say that this scorched earth tactics and the concept of, well, Your Honor, I have to represent my client zealously, is used as the excuse for a lot of the lack of civility, the scorched earth tactics, the delay, the misrepresentation. I'm sure you would echo that.
Yeah. I'm with the chorus here. You're right. That's their game. Like the one thing I'm going to tell you as lawyers is I ask you to do this. Drop that whole rap idea that stitches get stitches. If you don't tell us, if you don't ask a judge to do something, my obligation under Rule 7 of the Federal Rules of Civil Procedure is not to rule. Okay, I'm not allowed to go in there and just opine. I'm just going to talk about the economy today. I've got to answer a question, and I'm surprised how many people, to go to your point, call them out on it. Why don't they? Why don't the lawyers say, you know what's in Delaware, why they don't do it? There's only, and I don't know why, but there's only so many lawyers doing it, and nobody wants to call someone else out. In Philadelphia, in Texas right now, and in Pittsburgh, I don't know why they don't do it. I don't know why they don't say, hey, you know, Joe over there, Judge, something should be done about Joe.
And we have ways of bringing people to the bar of the Supreme Court to get disbarred, and they have been disbarred, but there's probably for every one that's been pursued, it's probably 6 or 7 that should be that you just don't.
You know, I ask you to get above the din of cynicism. Please get above. We've got to challenge this. And the cynic is saying, oh, you know, but for the grace is me. And I'm saying to you, no, it's not you. You're letting that slide. It's just that slippery slide. That my case, not a civil case, I attributed, in my opinion, to the idea that you can lie because people see on TV lawyers lying. Juries think lawyers lie not because they learned it in their civics classes, not because they learned it in high school, because they saw it on TV. That's why this is.
Well, what can we do? What can the profession do? What can the courts do to try to stop lawyers behaving badly, if you will?
Well, all right, I'll give you another example. In addition to the effort to hold those 5 and a few more are coming soon, then a few more complaints against some of the Trump lawyers, I'm involved in another project to hold lawyers accountable and to ensure there's some transparency. And together with a very small handful of law professors, I'm involved in this project. And the article that you mentioned about can you be a legal ethics scholar and have guts partly tells the story of how impossible it was to get law professors to sign on. And I actually think law professors should play a role in demanding accountability. Why? Because we have very little to lose. Most of my colleagues, I'm still a practicing lawyer, I run a clinic, I represent clients. I understand why lawyers who represent clients don't necessarily call out prosecutors or even judges who engage in misconduct because it might hurt the client. But law professors are in kind of a unique position. You know, ultimately, there's job security if you're tenured. What's the downside? The other project I'm involved in, the first locale is New York City, and what we're doing is we're taking prosecutors whom appellate courts have found to have engaged in prosecutorial misconduct, and we're filing complaints to follow up. And these are prosecutors against whom there have been a number of judicial opinions that are concerned about their conduct in inflammatory closing arguments, Brady violations, bats and the exercise of peremptory challenges in a racially discriminatory manner, those kinds of things. And we're attempting to follow up. All we're asking is that disciplinary boards do some investigation, because what has happened with those New York City prosecutors is 2 of 1. They've all been promoted after courts have scolded them for misconduct. And that has to stop. Rule 8.4 of the Rules of Professional Conduct, which some people mock as being a kind of catch-all, has in the comments, and I'm with you, Judge, sometimes there's more in the comments than there is in the rules. The rules can be a little inscrutable. Yeah. But the comment to Rule 8.4 says that lawyers who hold positions of public trust, who are in public office, have a higher responsibility than all of those, as they should, because they have a lot of power. And so I really believe in transparency. I think law professors should get involved. I think lawyers engaged in other kinds of practice than the practice area that's at issue should get involved as well.
Great. Well, we're here for the students, so we have a little bit of time left. And I think we'd be happy to well, and David has a question. Of course you may. It's your show.
No, I want to ask you a question because I think it will help maybe even provoke some other questions.
Can you hear? Okay. Speak up, please.
The question that I am posing is, what are the rules and what you can do in the court framework, in the pleadings, and what they do on television, and what the lawyers say that has no bearing at all on what they've pled? What have they done? Have they crossed the line when they do that? And I'm looking right at Ben because he and I litigated together on a whole bunch of cases. And we never did that. We stuck with what we pled.
Well, it's why lawyers don't always go on television. So look, that's going to go to really the question of professional ethics and personal ethics, where you hope they blend in. I mean, the stretching of the truth of what you plead in court to talk on TV is, I know that there are discussions in the rules about disciplining lawyers in their non-lawyer roles. But in all honesty, those, I think, cases are few and far between, and it does come right down to sort of the personal ethics of the lawyer. And it is also true that having been in the position of talking to media after cases, you don't always get asked or are expected to answer questions that square up exactly in what you've been able to present in court. In other words, at least in the political law arena, there's a larger political framework in which you're answering a question, even about a direct case, than you may have been talking about in court.
Yeah. Questions? Yes.
Me?
Yes.
Thank you for the discussion. I really enjoyed it, especially because I'm from a country that without the rule of law. I noticed in your...
Keep your voice up, please.
Oh, Yeah, I noticed in your talking that you mentioned two terms frequently. One of this democracy, the other is the rule of law. I wonder if you almost always view them as in working in conformity with each other, or do you feel one of the means, one of the end? If there's ever exists a conflict, will the lawyer be acting ethically to promote the rule of law or promote democracy?
Okay, that's a great question.
Can you repeat the question?
The question, as I understand it, is that we've talked about rule of law, however people interpret that, and we've also talked about democracy. And I think what you're saying is, can you still have in a country or in a forum supporting the rule of law without it being a democracy?
Yeah, I'm just wondering, do you always consider them, they're in conformity with, they're conform with each other, they're never a conflict?
Is one inherent, and I would say most times we would, because of the elements of a democracy, talking about independent judiciary, talking about the rules of fairness, we would say, we would look at a democratic government and hope that they have a strong rule of law. I don't think, and there are probably examples out there where you may have a more autocratic government, but there is still building towards a stronger rule of law in their country, and there's some, examples out there. We used to look at some of the countries, not Hungary anymore, because their autocracy has kind of moved way far over the other way. But I don't think they're mutually necessarily exclusive, and I think oftentimes that's how we look at it. If you're democratic, doesn't mean you even have a strong rule of law necessarily, as we're seeing here, it's dropping.
Okay, I think I asked a question in the context of democratic countries. I didn't mean any dictatorship. But I think in democratic countries, there's a rule of law. Is a rule of law, in a sense, lagging behind of the democracy? Like maybe the people's opinion, people always want more progressive, and the rule of law is on the other side because it is from older, it's already formed. So for me, it is always this conflict, and I don't know which one do you think it should be.
You can have a democracy that doesn't really value the rule of law as such. Democracy means it's a democratic process.
Yes.
So I think I think a key element of our democracy is the rule of law, but it's not necessarily so. Yes, over here. Sorry, I make you run.
So I really enjoyed you guys bringing up the topics about Rule 1.2 and the limits of a lawyer's personal views as associated with their client's views. I'm in Professor Janisson's legal profession class, and we actually had a really interesting discussion about that. And I wanted to hear all of your opinions about whether there's a difference of the applicability of Rule 1.2 in terms of representing a criminal client versus a client in a civil dispute, whether there should be any difference in public perception of attributing your own personal values of representing someone who's, has their liberty at risk versus their money at risk.
Let me take a shot at this one. So, the United States, unlike our Western allies, the UK, New Zealand, Australia, Canada, lawyers have a choice whether to take a case or not in the United States. In countries that have a divided profession, solicitors and barristers, there's supposed to be something called the cab rank rule, where you just take the next case that walks into your office. And so I think there is a moral moment in deciding whether to take on a case or not. And if you can afford to as a lawyer, I think you'd be wise to pick a case that comports with your personal values. I think that's especially so in a civil context, though maybe not in a poverty law, civil legal services context, where I think it's more analogous to court-appointed criminal cases or public defenders. I think for court-appointed counsel who choose to be on a court-appointed panel, the CJA panel in this country, or public defenders, I think the moral moment is in deciding to do that work. And once you decide to undertake indigent criminal defense, or indigent civil work, you are making a decision that you're not going to judge each case and decide that's too abhorrent for me. You are deciding to undertake the representation and to do so diligently, and I would say zealously, because I like the word zeal, and I'm glad at least it still exists in the comments.
Okay. Anyone else? Oh, one down here?
Hi, you guys talked a lot about, Judge Kearney specifically, you said snitches don't, or get stitches or whatever, and calling out other lawyers. But as someone who wants to go into indigent public defense, you have to work with prosecutors every day. You have to form a working relationship. How do you balance that call-out culture, I guess, or holding your co-lawyers accountable while also finding ways to work with them every day and be trusted so that your clients don't get punished, essentially, for you standing up for the work?
Well, as a judge, I don't think any judge would ever tell you, nor would we think we'd punish anybody for doing it. So I would defer that question to the lawyers. I just want to know. We'll make a decision based on the facts, but don't be afraid to tell us. And if you're right, if you think you're right, follow your conscience.
And I'll just add to that. I haven't practiced litigation in 30 years, but I would say that we need better mechanisms for people to raise issues anonymously, or when you're certifying every year to your bar, in my case, District of Columbia, are you aware of any issues? Can you tell us about this? Companies do that all the time. And I know you hear people saying, if it's anonymous, it doesn't really have credibility. Wrong. We've found over the years, and there are studies out there, over 50%, even higher, of people who raise things privately, confidentially, anonymously, are substantiated. So we need to do a better job. Law firms do I think, a terrible job of letting associates raise issues. They're intimidated. They feel their only way out. I hired a lot of people because they couldn't stay in a law firm because they felt like they couldn't raise issues. So I would say anonymity and confidentiality in our system is one of the ways to help address it.
Another is seek out help. One of our board members, Mary Gilbert, has an entity called Give Voice to Values, figuring out how to move these, how to speak up effectively so that if the person's really, if the person on the other side really acting out, something has to be done, and you don't really need a good relationship with that person because they shouldn't be there. But, if there's something else short of that, figuring out how to kind of go that route effectively. And there are resources out there, right?
And I just say, I agree with the student. I wouldn't. When I'm representing clients in a jurisdiction, criminal court is a community. And anonymity won't help me. They'll figure it out. If I offer up a specific example, they'll know that it came from my case.
And you might be concerned for your client.
Yes, it's going to hurt my clients down the road even. I won't get a decent plea offer. I'll be known as that scold who called out, that particular prosecutor. I want to defer back to the judges, Judge Rendell and Judge Kearney. I need some help from the bench, especially when it's misconduct that's present in court. I'm not saying I won't litigate on the record the issues that absolutely...
It's called, Counsel, can I see you in chambers?
Yeah.
Counsel, can I see you in chambers? I had one where somebody was on the stand and they were cross-examining and said, didn't you have a problem with illegal drug use? Okay, that's enough, everybody in chambers. Apparently, the man had been on had an infection, was on codeine or something, and the question was whether he was going for whether his memory was okay because he had taken a certain, medication. And I was one of my first jury trials. I said, if you ever try that again in my courtroom, you can send, trial judges can smell this stuff. And their antenna are up for the people who are going to do it.
And the people who do it repeatedly. And second, the best response I've done since then, the same thing that the judge has done, I stop the lawyers, and then I come back to the jury. Say, ladies and gentlemen, look at them, I'm their friend now. Ladies and gentlemen, what you just heard from Attorney Smith, you should entirely disregard.
That had nothing to do with it. Have a nice
What do you think about Attorney Smith, ladies and gentlemen? Don't do it.
But you seek help. Ask people. when in doubt, don't just plow ahead. I had a situation once where I could tell if I did something for this client, my reputation would be ruined with the other two lawyers in the case with whom I did work. And I kind of woke up in the middle of the night and said, I can't do this. I can't do this. And I went to talk to my partner and said, what do I do? You know? So there's help out there. There's help out there. Well, I hope this has been informative. I thank our panel members. I thank David and Connie for allowing us to